Welcome to your complete Missouri Real Estate Salesperson exam guide. Every question includes a clear explanation why wrong answers fail and the concept being tested. This session covers a broad practice set spanning ownership and land interests, real estate appraisal, mortgage financing basics, contracts and representation, Missouri real estate law. We've also built a website packed with free guides and practice questions to help you conquer your Missouri Real Estate Salesperson exam. Just check the link in the description to get started. It brings everything together in one place so you can study smarter, feel prepared, and walk into your exam with real confidence. All right, let's jump right in. Question 1. A commercial tenant installs display shelving and a walk-in cooler in a leased storefront in Springfield, and removes both at the end of the lease term. Repairing the damage caused by removal. Which of the following describes those items? Your options are A. Trade fixtures the tenant may remove. B. Fixtures that became part of the realty. C. Personal property the landlord may claim. D. Improvements requiring landlord compensation. Which one is it? Pause the video if you need more time. The correct answer is A. Trade fixtures the tenant may remove. A is correct because trade fixtures are articles a tenant attaches for business purposes and may remove before the lease ends, provided the tenant repairs any damage caused by removal. Ownership stays with the tenant throughout. B is wrong because annexation by a commercial tenant for business use is treated differently from annexation by an owner. The trade fixture doctrine exists precisely to prevent that conversion. C is wrong because the landlord has no claim to items the tenant installed for the business. Failing to remove them by the end of the term is what would leave them behind. D is wrong because no compensation arises when a tenant takes back her own property. Compensation questions surface with permanent improvements the tenant cannot remove at all. When personal property gets attached to real estate, the law usually says it becomes part of the building forever. But there's a major exception built just for tenants running a business, and understanding why it exists is the key to spotting it on an exam. Ordinarily, attaching personal property to a building converts it into real property that passes with the deed. Courts test this through 3 factors: the method of attachment, the adaptation to the building, and the intention of the person attaching it. Intention carries the most weight since the other 2 are just evidence of it. Here's the twist that exams love. An identical physical act produces opposite legal results depending on who performed it and why. An owner bolting down a walk-in cooler creates a fixture that conveys with the sale. A commercial tenant installing that same cooler for her own business creates a tray fixture that stays hers. 2 conditions protect the tenant's ownership. The equipment must be removed before the lease term ends, and any damage from removal must be repaired. Miss those and the equipment is treated as abandoned, passing to the landlord after all. Improvements like a concrete loading dock, a load-bearing wall, or a new roof can't be removed. So they belong to the building unless the lease says otherwise. And compensation is a trap. A tenant hauling off her own trade fixture has lost nothing, so nothing is owed. Just ask who attached it and why. Question 2. A Missouri property owner conveys her farm to her brother for the duration of his lifetime, with full ownership of the property passing to her niece the moment he dies. Which of the following describes the niece's interest? Your options are A. A determinable fee. B. A reversionary interest. C. A leasehold estate. D. A remainder interest. Take a second. Which answer would you pick? The correct answer is D. A remainder interest. D is correct because a remainder is a future interest held by a third party who takes when the life estate ends. Because the niece is someone other than the grantor, Her future interest is a remainder rather than a reversion. A is wrong because a determinable fee ends automatically on the happening of a stated event. The estate here is measured by a person's life, which is the defining mark of a life estate. B is wrong because a reversion returns the property to the grantor or her heirs. Naming a third party is exactly what converts the future interest from a reversion into a remainder. C is wrong because a leasehold gives possession for a fixed or periodic term in exchange for rent. The lease holds a future ownership interest rather than any right to occupy now. Every estate and land answers two questions: how long it lasts and who takes it next. A life estate lasts for a lifetime, which means the law must line up a future interest behind it from the very moment it's created. A life tenant gets almost everything an owner has. She can possess the land, farm it, collect rents, and even lease or sell her interest, but she cannot commit waste, and she cannot convey more than she holds. So any buyer's estate still ends at her death. The future interest waiting behind a life estate has one of two names, and only the identity of the holder decides which. If it returns to the grantor or her heirs, it's a reversion. If it goes to someone else named in the deed, it's a remainder. Picture a farm conveyed to a brother for his life, then to a niece. The brother holds present possession. The niece holds a remainder, ownership that exists right now, but grants no right to step on the land until the measuring life ends. Don't confuse a life estate with a determinable fee, which ends automatically when a stated event happens, or with a leasehold, where rent signals present possession without ownership. A life estate ends at a death and nothing else, while a remainder man owns ownership itself without possession. Question 3. A utility company holds the right to run power lines across a Missouri landowner's property, and that right benefits no neighboring parcel at all, only the utility itself. Which of the following describes the interest the utility holds? Your options are A. An easement in gross, B. A license revocable at will, C. An encroachment on the land, D. An easement appurtenant. Before I reveal it, which one do you think is right? The correct answer is A. An easement in gross. A is correct because an easement in gross benefits a person or entity rather than an adjoining parcel. Utility easements are the classic commercial example, and they survive changes in ownership of the burdened land. B is wrong because a license is mere permission the owner may withdraw. A recorded utility easement is a property interest that binds successive owners rather than a courtesy. C is wrong because an encroachment is an unauthorized intrusion onto another's land. This installation rests on a granted right, which is the opposite of an unauthorized intrusion. D is wrong because an appurtenant easement requires a dominant tenement that the benefit runs with. No neighboring parcel gains anything here, so the benefit attaches to the utility itself. When a utility runs power lines across 100 parcels, it isn't benefiting a farm next door. It's serving the whole grid, and that breaks the usual two-parcel easement model. An easement in gross is a right to use someone's land held by a person or entity in its own right. There's no dominant tenement. The benefit attaches to the utility itself, not to any nearby parcel it owns. An appurtenant easement, like a driveway crossing a neighbor's strip, runs automatically with the dominant land when it sells. A commercial easement in gross works differently. It's assignable, so a utility can sell its distribution system and the easement transfers right along with it, binding future owners once recorded. This is where it surfaces in real transactions. A recorded utility easement shows up on the title commitment as an exception to coverage. A buyer learns that a strip of the land carries someone else's permanent right of access, shrinking the buildable envelope. The key distinctions to keep straight: a license is bare, revocable permission with no interest in land, while an encroachment looks identical to an easement but has no right behind it at all. The question is always where the right came from. Attached to land means appurtenant. Attached to a person or company means engross. Question 4. A survey of a Kansas City lot reveals that the neighbor's garage extends 2 feet across the boundary line onto the seller's parcel near the rear fence line. Which of the following identifies what the survey has found? Your options are A. An easement by necessity. B. A party wall arrangement. C. An encroachment. D. A restrictive covenant violation. What's your answer? Commit to one before I continue. The correct answer is C. An encroachment. C is correct because an encroachment is an unauthorized intrusion of a building or improvement onto adjoining land. It clouds title, may affect marketability, and is typically discovered through a survey rather than a title search. A is wrong because an easement by necessity arises where a parcel would otherwise be landlocked. Nothing suggests the neighbor lacks access, and no easement was created here at all. B is wrong because a party wall is a shared structure the 2 owners agreed to build on the boundary. This garage was placed unilaterally and sits across the line. D is wrong because restrictive covenants are private limits recorded against a subdivision. A boundary intrusion is a trespass question rather than a breach of recorded use restrictions. A title search and a survey answer completely different questions, and understanding that gap is key to spotting encroachments. A title search reads the public record. A survey reads the physical ground. A title search reads deeds, mortgages, liens, and judgments. A survey reads where boundary lines actually fall and where structures actually stand. A defect existing only on the ground, never in a document, will not surface in a title search at all. An encroachment is an unauthorized physical intrusion of a building, fence, or driveway onto someone else's land. Picture a Kansas City lot where a survey reveals the neighbor's garage crosses the boundary by 2 feet near the rear fence, with nobody granting a right and no document recording the intrusion. Easement by necessity requires a landlocked parcel, and nothing here suggests the neighbor can't reach a road. A party wall requires mutual consent, but a garage built unilaterally cannot become one by accident. And a restrictive covenant governs use, not boundary lines. So a structure crossing a property line is a trespass, not a covenant violation. Watch for signal words like survey reveals, extends across the boundary, or intrudes onto the adjoining parcel. Whenever a physical structure sits where it has no right to be, and a survey rather than a title search turned it up, you found an encroachment. Question 5. 2 people take title to a Missouri rental house as joint tenants with right of survivorship, and one of them later sells her interest to an outside investor without telling the other. Which of the following describes the resulting ownership? Your options are A. The remaining owner takes the whole estate. B. The joint tenancy continues unchanged. C. The sale is void without joint consent. D. Buyer and remaining owner hold in common. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. Buyer and remaining owner hold in common. D is correct because a joint tenant may convey her interest, and the conveyance destroys the unities as to that share. The purchaser takes as a tenant in common with the remaining owner, who loses survivorship in that share. A is wrong because the remaining owner takes the whole, only if the co-owner dies while the joint tenancy stands. A lifetime sale removes that share from the survivorship arrangement. B is wrong because survivorship depends on the 4 unities remaining intact. A sale to a stranger breaks the unities of time and title as to the transferred interest. C is wrong because a joint tenant needs no permission to sell her own share. What she cannot do is convey more than she owns or defeat the other owner's interest. Joint tenancy is built entirely on 4 unities, and every rule in this area falls out of them. Joint tenants must take at the same time, through the same instrument in equal shares, with equal possession of the whole, break any one of these 4 unities as to a particular share, and that share stops being held in joint tenancy. The right of survivorship is not a contract between owners. It's simply what happens when the unities still hold at the moment of death. The deceased tenant's interest ceases, and it never passes through probate or to her heirs. When one owner sells to an outsider, the unities of time and title break as to that share, leaving only the unity of possession. The buyer becomes a tenant in common, while the remaining original owners stay joint tenants with each other, and survivorship keeps running only between them. A lifetime sale removes a share from the arrangement before death can ever reach it. So watch what the question describes. A death means survivorship controls, and a sale means severance controls, creating a tenancy in common. Question 6. A Missouri city needs a strip of privately held land to widen a road, and the owner refuses to sell. So the city files suit to acquire it and pay for it. Which of the following identifies the process? Your options are A. Escheat proceedings, B. Adverse possession, C. Condemnation under eminent domain, D. Inverse dedication. Which would you go with? Lock it in before the reveal. The correct answer is C. Condemnation under eminent domain. C is correct because eminent domain is the government power to take private property for public use, and condemnation is the legal proceeding that exercises it. The owner is entitled to just compensation for the taking. A is wrong because escheat transfers property to the state when an owner dies, leaving no heirs and no will. It requires no proceeding against a living owner and pays nothing. B is wrong because adverse possession rests on open, hostile occupancy for the statutory period. A city filing suit and paying compensation is doing the opposite of possessing without permission. D is wrong because dedication is a voluntary gift of land to public use, often by a subdivider recording a plat. This owner is refusing rather than dedicating anything. Government cannot function without the power to assemble land it doesn't own. Roads, schools, and sewer lines need specific parcels, so the sovereign retains the power to take private property for public use, and the owner's protection is a payment, not a veto. Eminent domain is the power itself, always held by government. Condemnation is the lawsuit filed to exercise that power when an owner refuses to sell. 2 requirements limit it: the taking must serve a public use, and the owner must receive just compensation, meaning fair market value, plus any damage to what remains. The sequence usually starts with negotiation, not lawsuits. The authority appraises the land, makes an offer, and only files suit when the owner refuses. Commissioners appointed by the court then view the property and file an award. Either side can demand a jury trial, and the government may take possession by paying that award into court while the value fight continues. Escheat moves property to the state from a dead owner with no heirs, so no one is paid. Adverse possession takes land without permission or payment, the opposite of condemnation. Dedication is a voluntary gift of land, so any refusal to sell rules it out. Inverse condemnation flips the roles. The government has already taken property, and the owner sues to demand payment. When a public body needs land, an owner won't sell, a suit gets filed, and compensation is paid. That's condemnation under eminent domain. Read every stem for who initiated the action and whether money changed hands, and the right answer becomes clear. Question 7. A commercial building in a Missouri suburb lawfully predates a zoning change that now prohibits its use entirely, and the owner simply continues operating exactly as it did before the change. Which of the following describes that building's status? Your options are A. An illegal use subject to abatement, B. A variance granted by the board, C. A special use permit holder. D. A legal non-conforming use. Don't overthink it. Which one feels right? The correct answer is D. A legal non-conforming use. D is correct because a legal non-conforming use is one that lawfully existed before a zoning change made it impermissible. The owner may generally continue the use, though expansion and rebuilding after destruction are often restricted. A is wrong because the use was lawful when it began. Zoning ordinances ordinarily protect uses already in place rather than criminalizing them the day the map changes. B is wrong because a variance is relief a board grants in advance for a hardship, typically involving setbacks or building dimensions. Nobody in this scenario applied to any board for anything at all. C is wrong because a special use permit authorizes a use the ordinance contemplates in that district on stated conditions. This use is now prohibited rather than conditionally allowed. When a zoning map changes and outlaws a business that was perfectly legal the day it opened, the law doesn't force it to close. This protected status is called a legal non-conforming use or a grandfathered use, and it explains almost everything zoning questions test. Zoning exists to protect public health, safety, and welfare, but it was never meant to destroy investments that were entirely lawful when made. Shutting down every business the moment a map changed would be a taking without compensation, so the law compromises by letting existing uses continue. The protection only covers the use exactly as it existed when the ordinance changed. Ordinances typically bar expanding it, converting it to a different non-conforming use, or reviving it after abandonment, and many prevent rebuilding if the structure is destroyed beyond a set threshold. The status attaches to the land, not the owner, so a buyer can continue exactly what the seller was doing, but cannot treat the sale as a fresh start to expand. A variance requires someone to ask a board for relief from hardship, and a special use permit covers a use the ordinance already contemplates under stated conditions. Neither applies here, because nobody applied for anything, and the use predates the ban rather than violating it. Question 8. A Missouri subdivision developer records a document against every lot, limiting them to single-family residential use and setting a minimum square footage for the houses eventually built there in future years. Which of the following identifies that document? Your options are A zoning ordinance, B, a building code amendment, C, covenants, conditions, and restrictions, D, a conditional use permit. Got a guess? Lock it in. The correct answer is C, covenants, conditions, and restrictions. C is correct because covenants, conditions, and restrictions are private controls a developer records against a subdivision. They bind successive owners and are enforced by other lot owners or an association rather than by government. A is wrong because zoning is a public control adopted by a municipality under its police power. A developer cannot enact zoning, and the two systems operate side by side. B is wrong because building codes govern construction methods, materials, and safety rather than how many families may occupy a house. Codes address how a structure is built. D is wrong because a conditional use permit is government approval for a specific use in a district. It comes from a public body rather than from a document the developer records. Land in a subdivision is controlled by two systems at once, and they come from completely different sources. Zoning is public, adopted by a municipality under the police power. Covenants, conditions, and restrictions are private, recorded by a developer against every lot. Both limit an owner, but satisfying one never excuses violating the other. A developer platting a subdivision records a declaration that binds every lot. The terms typically limit lots to single-family residential use, set a minimum square footage, impose setbacks, and route changes through an architectural review committee. Because it's recorded before the lot sale, every purchaser takes with notice and takes subject to it. Picture zoning and covenants as two separate layers sitting over the same lot. One traces back to city government and is enforced by a municipal inspector. The other traces back to a private developer and is enforced by neighbors or a homeowners association through a private lawsuit. Two questions sort this whole family every time. Who issued the instrument? Public body or private developer, and what does it govern? Use restriction or construction standard. Building codes fail on subject matter since they govern construction, not use. And whenever a covenant and a zoning ordinance both apply, the stricter one governs in practice. Restrictions run with the land, binding every later owner automatically without being restated in each deed. That durability is exactly why a developer chooses private covenants over zoning, to make a lasting promise about what the neighborhood will look like for years to come. Question 9. An appraiser valuing a 30-year-old house in a neighborhood of similar homes that sell frequently must select the valuation approach that best reflects what buyers in that market are actually paying today. Which of the following approaches fits? Your options are A. The cost approach, B. The income approach, C. The gross rent multiplier method, D. The sales comparison approach. Which one is it? Pause the video if you need more time. The correct answer is D. The sales comparison approach. D is correct because the sales comparison approach analyzes recent sales of similar properties and adjusts for differences. It is the most reliable approach for residential property where an active market of comparable sales exists. A is wrong because the cost approach estimates replacement cost less depreciation plus land value. It carries the most weight for new construction and for special purpose buildings with few comparables. B is wrong because the income approach capitalizes the net income a property produces. A single family residence bought for owner occupancy generates no income stream at all for an appraiser to capitalize. C is wrong because a gross rent multiplier is a rough screening tool applied to rental property. It relies on rent rather than on comparable sale prices and is not an appraisal approach. Sales comparison values a property by looking at what buyers just paid for similar homes and adjusting for the differences. Its authority rests on a simple idea. Value isn't cost or a bookkeeping number. It's what an informed buyer will actually pay. This rests on the principle of substitution. A rational buyer won't pay more than the cost of an equally desirable alternative. That logic works best where many similar homes trade often, like a 30-year-old subdivision of comparable houses. An appraiser picks recent sales similar in location, size, age, and features, then adjusts each comparable toward the subject. An extra bathroom on a comparable pushes its price down. A smaller lot pushes it up. Adjustments always move the comparable, never the subject. Sales comparison weakens exactly where good comparables disappear, which is why cost takes over for special purpose buildings. Income capitalization needs a rent stream, so it doesn't apply to owner-occupied homes at all. The gross rent multiplier is a quick screening tool, not an appraisal method, since it ignores expenses entirely. The real skill is reading a stem for what evidence actually exists, because whichever approach has the strongest evidence behind it is the one that carries the most weight. Question 10. An appraiser is asked to value a church building that almost never changes hands and produces no rental income at all for the congregation that owns and occupies it. Which of the following approaches will carry the most weight? Your options are A. The cost approach, B. The sales comparison approach, C. The income approach, D. An automated valuation model. Take a second. Which answer would you pick? The correct answer is A. The cost approach. A is correct because the cost approach estimates what it would cost to replace the improvements, subtracts accrued depreciation and adds land value. It suits special purpose properties that rarely sell and produce no income. B is wrong because comparable sales are scarce for special purpose buildings. An approach that depends on recent transactions loses much of its reliability when almost none of them exist. C is wrong because capitalizing income presupposes an income stream. A congregation occupying its own building generates no rent at all for the appraiser to work from. D is wrong because automated models rely on large volumes of market data on similar properties. Unique institutional buildings of this kind are exactly what such automated models handle worst of all. When a property rarely sells and generates no rent, both sales comparison and income approaches run dry. The cost approach exists for exactly the situation. The method works in 3 moves. Estimate the cost to build the improvements today, subtract accrued depreciation for age and wear, then add the land value as if vacant. The sum is the indicated value, since a buyer would pay no more than the cost of an equivalent site and building. The cost figure itself comes in 2 forms. Reproduction cost price is an exact replica, while replacement cost price is a building of equivalent utility using current materials. And appraisers favor replacement cost, since reproducing outdated plaster and mechanical systems produces a number nobody would pay. Appraisal depreciation has 3 sources: physical deterioration, like a worn roof or failing boiler, functional obsolescence, a defect in the design itself, and external obsolescence, value lost to causes outside the property line, such as a nearby highway. The first 2 originate inside the property, the third does not, and it generally cannot be cured by spending money on the building. The cost approach carries the most weight for new construction, where little depreciation exists to estimate, and for special purpose properties like churches and schools that rarely sell and earn no rent. Its weakness is judgment in depreciation, so reliability fades as buildings age. Question 11. An investor evaluating a Missouri apartment building divides the property's net operating income by the price similar buildings have commanded in the same local submarket over the past year. Which of the following identifies what she is calculating? Your options are A. The gross rent multiplier, B. The debt coverage ratio, C. The loan-to-value ratio, D. The capitalization rate. Before I reveal it, which one do you think is right? The correct answer is D. The capitalization rate. D is correct because the capitalization rate expresses the relationship between a property's net operating income and its value. Appraisers derive the rate from comparable sales and then apply it to the subject property. A is wrong because A gross rent multiplier compares price to gross rent rather than to net operating income. It ignores operating expenses entirely, which makes it a cruder measure. B is wrong because debt coverage compares net operating income to debt service. Lenders use it to test whether income covers the payment rather than to estimate value. C is wrong because loan to value compares the loan amount to the property's value. It is an underwriting measure of lender exposure rather than a valuation tool. 3 numbers sit in a fixed relationship at the center of income property valuation. And every exam question is really asking which one is missing: net operating income, the capitalization rate, and value. Net operating income divided by the rate produces value. Net operating income divided by value produces the rate. Value multiplied by the rate produces income. Know any 2 and you can solve for the third. Net operating income starts with potential gross income, subtracts vacancy and collection loss to reach effective gross income, then subtracts operating expenses like taxes, insurance, management, and reserves. What never comes out is debt service, depreciation, or income taxes, because those depend on the buyer, not the building. The rate isn't invented, it's extracted from comparable sales. Divide each property's net operating income by its sale price. That rate reflects how much risk investors perceive, and it creates the inverse relationship examiners love. Raise the rate and value falls, lower it and value rises. Even though nothing about the building changed. The gross rent multiplier ignores expenses entirely, which makes it a screening tool, not a valuation method. Debt coverage ratio and loan to value belong to the lender, testing debt service and collateral. The habit that sorts them all fast is asking exactly what numerator and denominator each measure compares. Question 12. A Missouri salesperson prepares a written opinion of value for a seller considering a listing, drawing on recent neighborhood sales and adjusting for condition, size and lot frontage differences. Which of the following describes what she has produced? Your options are A. A certified appraisal report. B. An automated valuation model output. C. A comparative market analysis. D. A broker price opinion requiring licensure. What's your answer? Commit to one before I continue. The correct answer is C. A comparative market analysis. C is correct because a comparative market analysis is a licensee's estimate of likely selling price based on comparable listings and sales. It informs pricing decisions and is not an appraisal by a licensed or certified appraiser. A is wrong because appraisal reports come from appraisers licensed or certified under a separate regulatory scheme. A salesperson producing one would be engaged in unauthorized appraisal practice. B is wrong because automated models generate estimates by algorithm from public and market data. No human adjustment for condition or size occurs, which is what distinguishes them. D is wrong because it mislabels the product and its requirements. A licensee may prepare a market analysis for a client under her real estate license without an appraiser credential. Two professions can put a number on the same house, and the line between them is drawn by statute, not skill. An appraiser produces an appraisal under a licensing scheme built for independence. A real estate licensee produces a comparative market analysis, a normal part of helping a seller price a listing. The separation exists because of what happened to the savings and loan industry. Loan losses traced in part to valuations made by people with a stake in the deal closing. So the federal response created licensing and uniform standards for appraisers. The point was independence. A federally related transaction needs a valuation from someone with nothing to gain. An appraiser is engaged to reach a supportable conclusion with no interest in the outcome. While a licensee preparing a market analysis is often competing for that very listing, creating pressure toward optimistic numbers. Appraisers also work under uniform standards for methodology, report content, and record retention that a market analysis simply doesn't have. A broker price opinion sits between the two, prepared for a lender or asset manager evaluating a distressed loan, not the same thing as a market analysis. An automated valuation model removes human judgment entirely, pulling assessment records and sales data into an algorithm that never walks the property or notices the failing roof. A licensee, a seller, and neighborhood comps point to a market analysis. A certified professional or a lending decision points to an appraisal. A figure with no human adjustment points to a model output. Remember, it's the credential and the purpose that classify these products, not how good the analysis is. Question 13. A borrower signs two separate documents at a Missouri closing, one promising to repay the debt and the other pledging the property as security for that promise to repay it. Which of the following describes the first document? Your options are A. The estoppel certificate. B. The deed of trust. C. The satisfaction of mortgage. D. The promissory note. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. The promissory note. D is correct because the promissory note is the borrower's personal promise to repay, setting out the amount, rate, and payment terms. The deed of trust is the separate instrument that pledges the property as security. A is wrong because an estoppel certificate is a statement confirming the current balance and terms of an obligation. Lenders and buyers request one during a transaction rather than at origination. B is wrong because the deed of trust is the security instrument rather than the promise to pay. It conveys title to a trustee to be held until the debt is satisfied. C is wrong because a satisfaction is recorded after the debt has been paid in full. It closes the transaction rather than creating the obligation at the outset. At every Missouri closing, a borrower signs two documents that do entirely different jobs. One is a promise, the other is a pledge. Nearly every mortgage law question turns on keeping those two apart. The promissory note is the promise. It sets the principal, the rate, and the payment schedule, and it creates personal liability for the borrower. Because it's a negotiable instrument, the lender can sell it, which is why payments end up going to a servicer the borrower never met. The security instrument is the pledge, and in Missouri, it's usually a deed of trust, not a mortgage. It involves three parties. The borrower as grantor conveys title to a trustee, who holds it for the lender's benefit until the debt is paid. Imagine either document alone. A note with no security instrument leaves the lender unsecured, standing in line with credit card companies. A security instrument with no note secures nothing, since no debt exists to secure. Together, the debt can be sold as an asset while the lien stays recorded against the property. Foreclosure enforces the deed of trust and reaches the property, while the note supports any deficiency claim. Releasing the lien and discharging the debt are separate acts. So when a stem describes two documents signed at the same closing, remember one creates the debt and the other attaches it to dirt. Question 14. A buyer obtains a conventional loan with a down payment well below 20%, and the lender requires coverage protecting itself against loss if she should default on the new loan. Which of the following identifies that coverage? Your options are A. Hazard insurance, B. Title insurance, C. Private mortgage insurance, D. A home warranty. Which would you go with? Lock it in before the reveal. The correct answer is C. Private mortgage insurance. C is correct because private mortgage insurance protects the lender against loss on a conventional loan with a low down payment. The borrower pays the premium and the coverage runs to the lender rather than to her. A is wrong because hazard insurance covers physical loss to the property from fire and similar perils. It protects the improvements rather than the lender's exposure on a small down payment. B is wrong because title insurance protects against defects in the ownership record. It addresses who owns the property rather than whether the borrower will make her payments. D is wrong because a home warranty covers repair or replacement of systems and appliances. It is a service contract for the buyer rather than protection for the lender. Private mortgage insurance exists because a 20% down payment locked out too many creditworthy buyers. It lets lenders accept a smaller down payment without absorbing extra risk. The borrower pays the premium, but the protection runs entirely to the lender. If foreclosure proceeds fall short, the insurer pays the lender the covered portion of that shortfall, not the borrower. Picture the foreclosure sale falling short of the loan balance. The insurer steps in and pays the lender directly, closing the gap the down payment didn't cover. 4 products can sit in the same file, each answering a different question. Hazard insurance covers fire and wind damage to the structure. Title insurance covers defects in ownership like forged deeds or hidden liens. And a home warranty is simply a repair service contract for the buyer's peace of mind. At every closing table, the organizing question is the same. Who is being protected and against what risk? Answer that and the right product identifies itself. Question 15. A borrower's monthly payment stays the same across the loan term, with the portion applied to interest falling and the portion applied to principal rising until the balance finally reaches zero at the end. Which of the following describes that loan? Your options are A fully amortized loan, B, an interest-only loan, C, a partially amortized balloon loan, D, an adjustable rate loan. Don't overthink it, which one feels right? The correct answer is A, a fully amortized loan. A is correct because a fully amortized loan retires the entire balance through level periodic payments over the term. Early payments are mostly interest and the principal share grows as the outstanding balance falls. B is wrong because an interest-only loan applies nothing to principal during the interest-only period. The balance stays unchanged, so it cannot reach zero through those payments. C is wrong because a partially amortized loan leaves a lump sum outstanding at the end. The payments are calculated on a longer schedule than the actual term, producing a balloon. D is wrong because an adjustable rate loan changes its rate on a schedule tied to an index. Its payments do not stay level, which is the defining feature described here. A fully amortized loan has a payment that never changes, and a payment that is never the same twice. Both are true at once, and understanding how is the whole concept. The word amortize literally means to kill off, and that's exactly the job. The lender sets one level dollar figure designed to cover all the interest and fully retire the principal by the maturity date. Interest is charged on the outstanding balance, so early on, most of the payment covers interest and only a little chips away at principal. As that balance shrinks, next month's interest shrinks too, freeing up more of the same payment to attack principal, and the effect compounds over the life of the loan. Watch what happens to the balance to tell these apart. A fully amortized loan's balance hits zero. An interest-only loan's balance never moves at all. A partially amortized loan leaves a lump sum balloon at maturity. And an adjustable rate loan can amortize fully, but its payment still moves whenever its index does. Level payment, declining interest, rising principal, balance ending at zero. That's the signature of full amortization. And tracking the balance separates all four loan types faster than any definition. Question 16. A lender carefully reviewing a residential loan application compares the applicant's proposed monthly housing payment and her total monthly debt obligations against her documented gross monthly income before approval. Which of the following identifies what the lender is measuring? Your options are A. Loan-to-value ratios, B. Debt ratios, C. Discount point exposure, D. The capitalization rate. Got a guess? Lock it in. The correct answer is B. Debt ratios. B is correct because debt ratios measure the share of a borrower's income consumed by the housing payment and by total monthly obligations. Underwriters use them alongside credit history and reserves to assess repayment capacity. A is wrong because loan-to-value compares the loan amount to the value of the property. It measures collateral coverage rather than the borrower's ability to make payments from income. C is wrong because discount points are prepaid interest paid to buy down the rate. They affect the cost of the loan rather than serving as an underwriting measure of capacity. D is wrong because capitalization rate is an appraisal concept relating income to value. It applies to income property rather than to a residential borrower's household budget. Underwriting a residential loan really asks two separate questions. Can the borrower make the payment from her income? And if she can't, is the property worth enough to cover the debt? The first is capacity, the second is collateral. And mixing them up costs points on material you actually understand. Capacity is measured with two ratios built from the same gross income figure. The housing ratio compares the proposed payment, including taxes, insurance, and dues, to gross monthly income. The total debt ratio adds every other recurring obligation, like car loans, student loans, credit cards, and child support. Gross income is used because withholding varies for reasons that have nothing to do with a borrower's ability to pay. A lender computes both ratios because they catch different problems. A borrower with a modest housing payment but heavy consumer debt can look fine on one ratio and fail the other, while a borrower with no other debt might support a payment that otherwise looks aggressive. Neither number alone describes the file, and neither ratio is an automatic gate. Compensating factors like reserves, credit history, and down payment size get weighed against the benchmarks. Loan to value answers the collateral question instead, comparing the loan amount to the appraised value or sale price, whichever is lower. It drives entirely different decisions: whether mortgage insurance is required, what rate the borrower gets, and how much cushion the lender holds in foreclosure. A borrower with pristine debt ratios can still be declined if the property won't support the loan. Discount points are just pricing prepaid interest to buy down the rate, not a measure of capacity. Capitalization rate belongs to income-producing property, not household budgets. Whenever a question compares what a borrower owes to what she earns, the subject is capacity. Full stop. Question 17. A Missouri seller signs an agreement giving one broker the right to a commission no matter who ultimately finds the buyer, including a buyer the seller happens to find on her own. Which of the following identifies that listing? Your options are A, an open listing, B, an exclusive agency listing, C, an exclusive right to sell listing, D, a net listing. Which one is it? Pause the video if you need more time. The correct answer is C, an exclusive right to sell listing. C is correct because an exclusive right to sell listing entitles the named broker to a commission regardless of who procures the buyer. It gives the broker the strongest protection and is the most common form used. A is wrong because an open listing lets the seller engage several brokers and pay only the one who produces the buyer. The seller may also sell herself and owe nothing. B is wrong because an exclusive agency listing protects the broker against other brokers but not against the seller. A seller who finds her own buyer owes no commission. D is wrong because a net listing describes how compensation is calculated rather than who earns it. Missouri prohibits net listings outright in both agency and transaction brokerage agreements. Listing agreements can feel like four confusing definitions, but they all sort along a single axis. Under what circumstances does the broker actually get paid? Answer that question and the whole family separates cleanly. Exclusive right to sell pays the broker no matter who finds the buyer, even the seller herself. Exclusive agency blocks other brokers but carves out the seller, who owes nothing if she finds her own buyer. Open listing drops exclusivity entirely, paying only whoever procures the buyer. Net listing isn't even on this axis, and Missouri bans it outright. A broker spends money on photography, advertising, signage, and staff time before ever earning a dollar. Letting the seller capture that spending and then close commission-free makes the investment irrational. So the market overwhelmingly chooses the form that protects it and avoids the procuring cause fight altogether. A net listing describes how pay is computed, not who earns it. The seller names a figure and the broker pockets everything above it. That structure sets the broker's financial interest against the seller's, which is exactly why Missouri prohibits net listings in both agency and transaction brokerage agreements. Every seller's agency agreement also needs a definite start and expiration date, no matter which type it claims to be. Master the payment question, and the whole category stops being four things to memorize and becomes one thing to reason through. Question 18. A buyer walks into an open house. and the listing agent begins advising her on what to offer and how to structure her financing, though the agent holds a written agency agreement with the seller alone. Which of the following risks does that conduct create? Your options are A. Breach of loyalty owed the seller client. B. Creation of an implied buyer agency. C. Conversion into an open listing. D. Loss of the broker's commission right. Take a second. Which answer would you pick? The correct answer is A. Breach of loyalty owed the seller client. A is correct because Section 339(7)30 RESMO requires a seller's limited agent to promote her client's interests with utmost good faith, loyalty, and fidelity. Coaching the other side on price and financing works directly against that duty. B is wrong because Missouri superseded the common law on whom agency duties are owed. A licensee becomes a buyer's agent only through a written agreement, and absent one she remains a transaction broker. C is wrong because listing type is fixed by the contract the parties signed. Nothing a licensee says at an open house rewrites the compensation arrangement with the seller. D is wrong because commission rights flow from the listing contract. Conduct of this kind creates duty and liability exposure rather than automatically forfeiting compensation the broker has already earned. An agent means well, chatting with a buyer about offers and financing, but that helpful conversation is the most common breach of loyalty in residential practice. Missouri's brokerage statute states this in strong terms: an agent must perform the agreement, act with utmost good faith, loyalty and fidelity, and seek a price acceptable to her own client. Loyalty here is directional, running to one party only. The agent does owe the buyer real duties, but their floor-level obligations owe to everyone: honesty and fair dealing, disclosure of adverse material facts, accounting for money and property, and reasonable skill and care. Advocacy is different and it belongs to the client alone. Advising the buyer on price or financing strategy is advice that improves her position at the seller's expense. The agent has shifted from serving her client to helping the party across the table. No written agreement means no accidental buyer agency, and the listing and commission stay intact. But the exposure is real: a breach claim and a disciplinary matter, worse than any lost commission. Always ask whose position the advice improves. Question 19. A brokerage agrees to represent both the seller and the buyer in the same transaction, and both parties are told in advance and agree in writing before any negotiation actually begins. Which of the following describes that arrangement? Your options are A. Undisclosed dual agency. B. Disclosed dual agency. C. Subagency of the seller. D. A single agency relationship. Before I reveal it, which one do you think is right? The correct answer is B. Disclosed dual agency. B is correct because disclosed dual agency is representation of both parties with the informed written consent of each. Undisclosed dual agency is prohibited everywhere and exposes the licensee to discipline and civil liability. A is wrong because both parties were told before negotiation began. The vice in undisclosed dual agency is that a party never learns the licensee also serves the other side. C is wrong because subagency arises when another broker works on behalf of the listing broker's client. Here one firm represents both sides rather than extending the seller's representation. D is wrong because single agency means representing only one party in the transaction. Representing both sides at once is precisely what takes this arrangement outside that particular category. Dual agency asks one person to fully advocate for two parties whose interests directly conflict. In the pure sense, that's impossible, so the law doesn't pretend otherwise. Instead, it regulates a compromise, allowing the arrangement only with informed written consent obtained before negotiations begin. Two elements carry all the weight in disclosed dual agency. The consent must be informed, meaning both parties truly understand neither gets full advocacy, and it must come before negotiations start, because consent obtained afterward protects nobody. What she may not do defines the role more clearly than what she may. She cannot disclose the seller's lowest price or the buyer's highest, reveal either side's motivation or urgency, share confidential information, or advocate a position for one side against the other. Plenty remains, which is why the arrangement persists. She can present offers and counter-offers accurately, supply market data, explain financing and inspection mechanics, prepare documents, coordinate closing, and disclose adverse material facts. The role shifts from advocate to facilitator. Undisclosed dual agency is prohibited without exception, because the harm isn't serving two parties. It's a client believing she had an advocate she didn't. Missouri's designated agency structure avoids much of this by giving each party her own advocate within the same firm. Question 20. A listing expires without a sale, and the seller asks whether the broker may still tell a prospective buyer what the seller confided about her financial pressure to move quickly before the listing ran out. Which of the following describes the duty? Your options are: A. Confidentiality survives the relationship. B. Confidentiality ends with the listing. C. Confidentiality ends once the property relist. D. Confidentiality applies only during negotiation. What's your answer? Commit to one before I continue. The correct answer is A. Confidentiality survives the relationship. A is correct because the duty to keep client confidences survives termination of the agency relationship. In Missouri, the statute preserves both confidentiality and the duty to account after a brokerage agreement ends. B is wrong because a client's willingness to accept less would be worth little if the licensee could publish it the day the listing lapsed. The protection would be meaningless. C is wrong because relisting with another firm does not release the former broker. The seller's earlier disclosures were made in confidence and remain protected regardless of who lists next. D is wrong because it confines the duty to the moments when a deal is being struck. Confidential information disclosed at a listing appointment is protected just as fully. When an agency relationship ends, most duties switch off immediately, but two obligations survive termination, and understanding why reveals what these duties were really protecting all along. The duty to follow lawful instructions ends. The duty to market the property ends. But confidentiality and the duty to account for money and property survive termination, exactly as Missouri's statute requires. Confidentiality covers what a client reveals that would weaken her position, her lowest acceptable price, her reason for selling, a financial pressure forcing a quick sale. But it never covers adverse material facts about the property itself, like a leaking roof or cracked foundation. The most sensitive disclosures happen at the listing appointment months before any expiration. If confidentiality ended with the listing, no seller would ever speak candidly, and the broker would lose the trust needed to represent anyone well. Relisting with another firm doesn't release the former broker, and neither does time passing. Only written consent, a court order, or a statute can lift the duty. Otherwise, confidentiality outlasts the paper that created it. Question 21. A Missouri seller signs an agreement in which the licensee promises to market the property and the seller promises to pay a commission on a successful sale of the property. Which of the following describes the contract they formed? Your options are: A unilateral contract, B, a bilateral contract, C, an executed contract, D, a voidable contract. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B, a bilateral contract. B is correct because a bilateral contract consists of a promise exchanged for a promise, and both parties are bound from the moment of formation. Each side owes performance, which distinguishes it from a one-sided promise. A is wrong because a unilateral contract is a promise in exchange for an act, binding only the offerer until performance occurs. An option agreement is the classic real estate example. C is wrong because an executed contract is one both sides have fully performed. This agreement has just been signed, so performance still lies ahead for both parties. D is wrong because voidable describes a contract one party may disaffirm, usually for lack of capacity or because of fraud. Nothing in these facts creates that power. Contract classifications aren't one list, they're 4 separate axes, and a single contract sits somewhere on all 4 at once. Confusing the axes is where most wrong answers come from. One axis asks how the agreement was formed, a promise for a promise or a promise for an act. Another asks how it was expressed, in words or through conduct. A third asks how far performance has progressed, and a fourth asks what legal effect the contract carries. A bilateral contract forms when both sides exchange promises and both are bound immediately, like a listing agreement. A unilateral contract forms when a promise is exchanged for an act, like an option, where only the offerer is bound. Executory simply means performance hasn't happened yet, regardless of how the deal was formed. The legal effect axis has its own vocabulary. A valid contract binds both parties completely. A void agreement was never a contract at all. A voidable contract is binding unless a party with a formation defect disaffirms it. An unenforceable contract is real but can't be enforced in court. Voidable requires a real defect in formation, like fraud or duress, not just regret over a bad deal. Before answering, ask which axis the question is really testing, and the 4 terms stop collapsing into one. Question 22. A buyer submits an offer, and the seller returns it with a higher price and a different closing date, which the buyer then declines. The buyer asks whether she may now accept the original terms. Which of the following describes her position? Your options are: A. The original offer remains open until expiration. B. Either party may revive the original terms. C. She may accept if unsold. D. The counteroffer terminated the original offer. Which would you go with? Lock it in before the reveal. The correct answer is D. The counteroffer terminated the original offer. D is correct because a counteroffer rejects the original offer and substitutes a new one. Once the seller countered, the buyer's original offer ceased to exist and there is nothing left for her to accept. A is wrong because the stated expiration governs only an offer that is still alive. A counteroffer ends the offer regardless of how much time remained on its face. B is wrong because reviving terminated terms requires a fresh offer and acceptance. The parties may certainly agree to the original numbers again, but only by contracting anew. C is wrong because whether the property sold is beside the point. The offer terminated when the seller countered, so its availability does not turn on later events. An offer gives its recipient a power to accept, but that power belongs only to them and only for as long as the offer survives untouched. Acceptance must mirror the offer exactly, be unqualified, and be communicated. Change even one term and you haven't accepted anything at all. A counteroffer does 2 things in one move. It kills the offer it responds to, and it replaces it with a new proposal, flipping who holds the power to accept. Counteroffer is just one of several ways an offer terminates. Rejection, counteroffer, lapse of time, revocation, death or incapacity, destruction of the subject matter or supervening illegality. Only counteroffer and rejection require anyone to say anything. Once the seller countered, the buyer's original offer ceased to exist, expiration date or not. Reviving those terms needs a brand new offer and acceptance, not a unilateral change of mind. Question 23. A purchase agreement provides that the buyer's obligation depends on obtaining financing at a stated rate within 30 days of acceptance, and she cannot obtain it despite a diligent and documented effort. Which of the following describes the provision? Your options are A contingency the buyer may rely on, B, a liquidated damages clause, C, a condition subsequent voiding title, D, an option the seller granted her. Don't overthink it, which one feels right? The correct answer is A, a contingency the buyer may rely on. A is correct because a contingency makes performance depend on a stated event occurring within a set period. If the condition is not satisfied despite good faith effort, the buyer may withdraw and recover her earnest money. B is wrong because liquidated damages fix in advance what a breaching party forfeits. The buyer here is not breaching at all. A condition to her duty simply failed. C is wrong because a condition subsequent is a limitation on an estate that can end ownership after title passes. Nothing in this contract concerns the quality of the estate conveyed. D is wrong because an option gives the holder an exclusive right to buy for a price during a period. This buyer is already under a binding purchase contract instead. A buyer signs a purchase contract before she knows whether a lender will approve her, what an inspector will find, or whether her current home will sell. Without some mechanism for handling that uncertainty, she'd face a choice between reckless commitment and no deal at all. That mechanism is the contingency. A contingency makes a party's obligation depend on a stated event happening within a set time. It's a condition attached to a duty, not a promise that the event will occur. When the condition fails, the duty simply never matures and nobody has breached anything. A well-drafted contingency has 4 moving parts. It names the event. Like obtaining financing, it sets a measurable standard. Like a loan at or below a stated rate, it fixes a deadline. Like 30 days from acceptance, and it specifies the consequence of failure, usually known as termination, and return of earnest money. Vagueness in any of these 4 is where litigation comes from. Good faith is what keeps this device honest. A buyer must actually pursue financing with diligence, applying promptly and documenting the effort. Because a buyer who never even applies hasn't satisfied a condition, she's manufactured an excuse, and courts treat that as a breach. The contingency only protects the party it was written for, so that party alone can waive it and proceed anyway. And unlike liquidated damages, an option, or a condition subsequent in property law, a true contingency means that when it fails despite genuine effort, no one has breached at all. Question 24. A buyer under contract wants to transfer her rights and duties to her business partner before closing, and the contract itself says nothing at all about whether she may do so. Which of the following describes the general rule? Your options are A. Real estate contracts are never assignable. B. Assignment requires a seller release. C. Assignment requires recording with the county. D. Contracts are assignable unless prohibited. Got a guess? Lock it in. The correct answer is D. Contracts are assignable unless prohibited. D is correct because contracts are generally assignable unless the agreement forbids it or the duties are personal in nature. The assigner ordinarily remains liable unless the other party agrees to a novation. A is wrong because a blanket prohibition would prevent common practices such as assigning a purchase contract to a newly formed entity. Parties may restrict assignment, but the default runs the other way. B is wrong because a release is what a novation accomplishes and it requires the seller's agreement. Assignment itself can occur without the original buyer being let off the hook. C is wrong because recording concerns instruments affecting title in the public records. A contract assignment between the parties needs no filing with the recorder to be effective. Most people assume transferring a real estate contract needs the other side's permission. The actual default rule runs the opposite way. Contracts are assignable unless the agreement prohibits it or the duties are personal in nature. Assignment transfers the assigner's rights to a third party, while delegation hands over her duties. But assignment never releases the original party from liability. Only a novation, a new agreement with everyone's consent, actually discharges someone from the deal. The exception is personal duties, when performance depends on someone's identity, skill, judgment, or credit. The contract isn't freely assignable. A listing agreement is the classic example, since a seller picked that specific broker for her reputation and marketing, not just any agent at the firm. Recording is a distractor. It gives notice of instruments affecting title to land, like deeds, easements, liens, and plats. But an assignment of contract rights is just an agreement between two parties, not a conveyance of land. So it takes effect without any filing. In practice, most purchase forms address assignment directly. But where the document is silent, assignability is the starting point, and the burden falls on whoever wants to stop the transfer. Question 25. A purchase agreement states that time is of the essence with respect to the closing date, and the buyer appears 3 days late with her funds finally in hand. Which of the following describes the effect of that clause? Your options are: A. The delay is immaterial without damages. B. It applies only to the seller. C. Deadlines must be met exactly as written. D. It converts the contract into an option. Which one is it? Pause the video if you need more time. The correct answer is C. Deadlines must be met exactly as written. C is correct because A time is of the essence clause makes the stated deadlines material terms. A party who performs late has breached even where the delay is short and the other side suffered no measurable harm. A is wrong because the clause removes the flexibility courts otherwise apply to minor delays. Its whole function is to make timing itself a material condition of performance. B is wrong because the clause governs the contract rather than one side of it. Both buyer and seller are held to the dates the agreement sets out. D is wrong because an option gives one party a right to buy without an obligation. This buyer is bound to purchase, and the clause tightens her deadline rather than releasing her. Contract law usually forgives small delays. Courts let a party finish late if the lateness caused no real harm. A time is of the essence clause exists specifically to erase that forgiveness. Normally, courts treat a late closing date as a minor inconvenience, not a broken promise, and they'll grant reasonable extra time rather than let a deal collapse over a delay that costs nobody anything. That flexibility is the default the clause is written to remove. The clause converts every stated deadline into a material term. So a party who performs late has breached, whether the delay was 3 days or 30, and whether or not it caused any damage. It binds both sides equally, and neither party has to prove the delay actually hurt them, because materiality is baked in. A seller facing a late buyer can terminate and often keep the earnest money. A buyer facing a late seller can terminate and recover her deposit. But a party who accepts late performance, keeps negotiating, or reschedules without objection can waive the clause entirely. So enforcing it requires acting like you mean it. This is different from an option which lets someone buy without any obligation at all. A time is of the essence clause does the opposite. It keeps the buyer obligated to close, just under a much stricter deadline. Question 26. A buyer delivers an earnest money check with her offer, and the seller's agent explains to her that the deposit shows the buyer's seriousness about the purchase. Which of the following describes the legal role of that deposit? Your options are: A. It is the contract's consideration. B. Good faith evidence credited at closing. C. It is a non-refundable option payment. D. It transfers equitable title to the buyer. Take a second. Which answer would you pick? The correct answer is B. Good faith evidence credited at closing. B is correct because earnest money evidences the buyer's good faith and is credited toward the purchase price at closing. The mutual promises in the agreement supply the consideration that makes the contract binding. A is wrong because a purchase agreement is supported by the exchange of promises. Contracts with no earnest money at all can be entirely valid and enforceable. C is wrong because an option payment buys a right to decide later and is typically not refundable. Earnest money returns to a buyer whose contingency fails through no fault of her own. D is wrong because equitable title passes on formation of an enforceable contract rather than through the deposit. The size of the check has nothing to do with that doctrine. Earnest money is the most misunderstood check in real estate. It shows good faith, but it is not what makes the contract binding. A contract is bound by consideration, and in a purchase agreement that consideration is the exchange of promises. The buyer promises to purchase, the seller promises to convey, and no money has to change hands for the parties to be bound. Disposition on failure is what parties actually fight about. If a contingency fails through no fault of the buyer, the deposit is returned. If the buyer defaults without excuse, the seller typically retains it, and if the parties disagree, the broker simply holds the funds until they agree in writing or a court decides. Handling is where license law enters. The deposit must go into the broker's escrow or trust account, kept separate from operating funds, with records showing whose money it is, and a licensee must deliver it to a broker rather than holding or spending it herself. An option payment buys the right to walk away and is usually non-refundable, while earnest money returns if a contingency fails. An equitable title shifts to the buyer the moment the contract is enforceable, regardless of the deposit size. Question 27. Several competing Missouri brokers meeting privately at an association luncheon agree informally among themselves that none of them will list residential property for a commission below a stated minimum rate. Which of the following describes that informal agreement? Your options are A. A lawful trade association standard. B. A group boycott of low-cost firms. C. A permissible market allocation. D. Price fixing prohibited by antitrust law. Before I reveal it, which one do you think is right? The correct answer is D. Price fixing prohibited by antitrust law. D is correct because competing brokers agreeing on commission rates is price fixing, a per se antitrust violation. Commission rates must be negotiated independently between each brokerage and its own client, without industry coordination. A is wrong because no trade association may set rates for its members. Associations may publish education and ethics standards, but pricing must remain a matter for each firm. B is wrong because a group boycott is a concerted refusal to deal with a particular competitor or vendor. Nobody here agreed to refuse dealings with anyone. C is wrong because market allocation is a different violation, dividing territories or customer types among competitors. These brokers agreed on price rather than on who serves whom. Some agreements among competitors are illegal automatically with no need to prove they caused harm. This category is called per se illegality, and price fixing among real estate brokers sits right at its center. Competing brokers agreeing on what to charge is price fixing in any form. A specific rate, a minimum rate, a floor, a standard fee schedule, or a uniform split with cooperating firms. The violation happens the moment the agreement is made, even at an informal lunch, before a single listing is ever taken. Nothing about this needs to be formal. No signed document, no meeting minutes are required, since an informal understanding reached in conversation counts as an agreement, and the casual setting is never a defense. Price fixing has two relatives in the same family of violations. Group boycott is a concerted refusal to deal, like agreeing to freeze out a discount brokerage, while market allocation is dividing territories or customer types so competitors stop competing for each other's business. Rates must always be set independently by each firm and negotiated with its own clients. If a conversation with competitors ever turns to rates, the safest move is to leave immediately and document it. Question 28. A Missouri salesperson buys a list of telephone numbers and begins cold calling homeowners whose numbers appear on the Federal Registry, hoping to win new listings in her own suburban neighborhood. Which of the following describes that practice? Your options are A. Restricted by do not call registry rules. B. Permitted if she identifies her brokerage. C. Permitted because the calls concern real estate. D. Permitted during ordinary business hours. What's your answer? Commit to one before I continue. The correct answer is A. Restricted by do not call registry rules. A is correct because federal do not call rules restrict telephone solicitation to numbers on the National Registry, with narrow exceptions for existing business relationships and express written consent. Real estate solicitation carries no blanket exemption. B is wrong because identification requirements are separate from the registry prohibition. A caller must identify herself, and doing so does not authorize calling a registered number. C is wrong because the subject of the call does not create an exemption. The rules address unsolicited telemarketing calls generally rather than singling out any particular industry for special treatment. D is wrong because permissible calling hours are an entirely distinct restriction. Confining calls to reasonable hours does not permit contacting the numbers that the registry protects. A salesperson identifies herself, calls at reasonable hours, and stays polite. Yet she's still breaking federal telemarketing law. That's because each rule she followed answers a completely different question than the one she violated. The National Registry restricts solicitation calls to residences, and the exceptions are narrow. An established business relationship, written consent, a genuine personal relationship, or a call that isn't a solicitation at all, these are the only lawful paths onto a registered number, and real estate gets no special exemption. Identification, business hours, and an internal do not call list are all genuine separate requirements. Satisfying one of them does nothing to excuse breaking another. Each stands on its own. Beyond the National Registry, a firm must keep its own internal do not call list, train callers and keep records, and maintain a written policy on request. None of these substitutes for checking the registry itself. Penalties apply per call, turning a purchase list into an existential risk rather than a citation. Lawful prospecting means scrubbing against the registry, keeping an internal list, documenting consent, and treating every requirement as independent. Question 29. A Missouri broker compensates her affiliated licensees solely by commission and does not withhold taxes, while still requiring them to follow the firm's written policies and supervising their work under her office policy. Which of the following describes that arrangement? Your options are A. An arrangement Missouri law prohibits. B. Employment requiring withholding regardless. C. A partnership among the affiliated licensees. D. Independent contractor status with supervision duties. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. Independent contractor status with supervision duties. D is correct because Missouri expressly contemplates salespersons associating with a broker as independent contractors compensated solely by commission, while the commission's rules impose a supervision duty on that broker, regardless of tax classification. A is wrong because the statute protects this arrangement rather than forbidding it. Independent contractor status is the norm across the industry and is expressly recognized here. B is wrong because tax treatment follows the arrangement the parties structure within the applicable rules. Missouri does not convert every affiliated licensee into an employee for withholding purposes. C is wrong because affiliated licensees working under one broker form no partnership. A partnership would require an agreement to share profits and losses as co-owners of a business. A broker pays her agent straight commission with no tax withholding, yet she still writes the office policies, reviews every contract, and supervises their work. That looks contradictory only if you assume control and tax status must travel together. They don't, and understanding why unlocks one of the most durable arrangements in real estate. Tax law asks who controls the details of how work gets done to decide if withholding is required. License law asks who is accountable to the public to decide where responsibility lands when something goes wrong. Because the two questions serve different purposes, they can produce different answers about the very same person. Missouri expressly allows salespersons to work as independent contractors paid solely by commission, and federal tax rules back this with a safe harbor. But the supervision duty never softens. Written office policies, review of contracts and advertising, control of escrow funds, and being reachable for guidance are all still required of the broker. The two systems coexist because controlling the manner of work is not the same as controlling regulated conduct. A broker who sets hours and dictates methods undermines independent contractor status, but a broker who enforces license law and a written policy manual is simply discharging the duty the state placed on her. A broker cannot excuse a failure to supervise by pointing to independent contractor status, and partnership doesn't fit either, since licensees share an office and a broker, not ownership of a business. When commission-only pay, no withholding written policies, and supervision all appear together, that's simply independent contractor status coupled with supervision duties. Question 30. A Missouri brokerage occupying a ground floor office in a strip center is asked by a prospective client who uses a wheelchair to make the front entrance usable for her visits. Which of the following describes the obligation? Your options are: A. No obligation exists for private offices. B. The obligation falls on the landlord alone. C. Reasonable accessibility for public accommodations. D. Full reconstruction of the building is required. Which would you go with? Lock it in before the reveal. The correct answer is C. Reasonable accessibility for public accommodations. C is correct because a real estate office open to the public is a place of public accommodation, and accessibility obligations require readily achievable barrier removal and reasonable modifications to policies and practices. A is wrong because privately owned businesses serving the public carry these obligations. Ownership by a private firm does not remove a place of public accommodation from coverage. B is wrong because responsibility can rest with both the landlord and the tenant depending on the lease. A brokerage cannot simply point upstream and disregard access to its own office. D is wrong because the standard is readily achievable removal of barriers rather than wholesale rebuilding. Cost and feasibility are part of the analysis for existing buildings. A brokerage office is a place of business open to the public, not a dwelling. That single distinction determines which law applies, not fair housing law, but the law governing public accommodations. A place of public accommodation is a privately owned facility whose operations affect commerce and which serves the public. This broad category expressly includes offices of service providers, so a brokerage in a strip center qualifies, and private ownership is not an exemption. For existing buildings, the standard is readily achievable barrier removal, easily accomplishable fixes judged against available resources. Think a ramp at a single step, lever hardware, a buzzer with signage, rearranged furniture, an accessible parking space, or a lowered counter. Alongside barrier removal sits a second, easier duty, reasonable modifications to policies and procedures, unless that would fundamentally alter the business, like meeting a client elsewhere or accommodating a service animal. Newly built or altered space, though, faces a stricter rule. It must be fully accessible as designed, with no cost and feasibility escape valve. Whether it's the landlord or the tenant, responsibility for access can't be pointed away. A lease may allocate cost, but not obligation. When a client with a disability asks about physical access to an office, the answer is an assessment of what can readily be done now. Question 31. A Missouri listing agent knows the roof of the house has leaked repeatedly during heavy storms, and the buyer never once asks about it before making an offer on the house. Which of the following describes the agent's duty? Your options are: A. She must disclose the adverse material fact. B. She may stay silent unless asked directly. C. She must disclose only after acceptance. D. She must obtain a roof inspection first. Don't overthink it. Which one feels right? The correct answer is A. She must disclose the adverse material fact. A is correct because a Missouri limited agent must disclose to any customer all adverse material facts actually known, or that should have been known. A recurring roof leak is a defect the buyer is entitled to learn about. B is wrong because the duty does not wait on a question. Concealing a material fact is also a disciplinary ground under the license law, regardless of what the buyer asked. C is wrong because disclosure after acceptance comes too late to inform the decision. The point of the duty is that the buyer can weigh the condition before committing. D is wrong because no inspection obligation attaches to the licensee. She has no duty to investigate, which does not excuse silence about a defect she already knows. A Missouri licensee's duty to a customer she doesn't represent is narrower than her duty to her client, except for one duty that isn't narrow at all, disclosing adverse material facts. The statute defines an adverse material fact as something not reasonably known, that bears on the property's physical condition, on title or legal use, on a party's authority to complete the transaction, or on a party's ability to perform. A roof that leaks repeatedly in storms fits the first category. The duty does not wait on a question. Silence itself is the violation, because the buyer who never thinks to ask is exactly the person the rule protects. Timing matters. Disclosure must come before the buyer commits, since revealing a defect after acceptance only forces a renegotiation, not an informed decision. The licensee owes no duty to investigate or inspect, only to disclose what she actually knew or should have known. Concealing a known fact exposes her to discipline before the commission and civil liability before a court. The signal is always the same: a licensee who knows, a buyer who never asked. Where there is knowledge and silence, the disclosure duty controls. Question 32. A buyer contracts to purchase a home built in 1968, and federal law entitles her to a period in which to investigate a particular hazard unless she waives that opportunity in writing. Which of the following identifies that hazard? Your options are: A. Radon gas accumulation. B. Underground storage tanks. C. Lead-based paint. D. Asbestos insulation. Got a guess? Lock it in. The correct answer is C. Lead-based paint. C is correct because federal law covers target housing built before 1978, requiring the disclosure pamphlet, a warning statement, disclosure of known hazards, and a 10-day opportunity to inspect that the parties may waive. A is wrong because no federal statute imposes a radon disclosure or inspection period on residential sales. Radon testing is common practice rather than a federally mandated opportunity. B is wrong because storage tank obligations arise under environmental programs aimed at owners and operators. No federal residential sale disclosure period of the kind described here attaches to them. D is wrong because asbestos regulation focuses on schools, workplaces, and renovation practices. Residential resales carry no federal inspection window at all comparable to the one described here. Lead paint was banned from residential use in 1978, and that date drives the entire federal disclosure rule. Lead made old paint durable and color fast, but it damages the developing nervous systems of young children who put chips and dust in their mouths. Because the danger is old paint in old housing rather than an ongoing practice, the rule targets the transaction itself. Target housing means residential property built before 1978, with narrow exceptions for elderly or disabled housing with no resident child and 0-bedroom dwellings. Before a purchase contract becomes binding, 4 things must happen. The buyer gets an approved federal pamphlet, the contract carries a specific warning statement, the seller discloses known lead hazards and records, and the buyer gets a 10-day window to inspect. The distinctive feature is that the buyer may waive this inspection in writing, and parties can agree to a different length, but the seller can never skip offering the opportunity altogether, and licensees are personally liable if they let that happen. Radon, storage tanks, and asbestos are all hazards, but none carries this federal disclosure package. Whenever a STEM pairs a pre-918 home with a waivable inspection opportunity, the hazard being tested is lead-based paint. Question 33. A buyer at a Missouri closing is offered 2 separate title policies and chooses to purchase the one protecting her own interest against undiscovered defects in the record chain of title. Which of the following identifies that policy? Your options are A. A lender's policy, B. An owner's policy, C. A mechanic's lien endorsement, D. A survey endorsement. Which one is it? Pause the video if you need more time. The correct answer is B. An owner's policy? B is correct because an owner's title policy ensures the buyer's interest against covered title defects, typically for the purchase price. The lender's policy protects only the lender and decreases as the loan balance falls. A is wrong because a lender's policy runs solely to the lender's benefit. A buyer who buys only that coverage has protected the bank rather than her own equity. C is wrong because an endorsement modifies coverage on an existing policy for a specific risk. It is an add-on rather than the policy protecting the owner's interest. D is wrong because a survey endorsement addresses boundary and encroachment matters shown by a survey. It supplements coverage rather than serving as the owner's basic protection. At closing, a buyer is handed 2 very different title policies, and it's easy to miss that they protect 2 different people. One insures her, the other insures the bank. An owner's policy insures the buyer's interest, usually for the full purchase price, against defects like a forged deed, an unknown heir, or a recording error. A lender's policy insures only the lender, only up to the loan balance, and it shrinks and eventually disappears as the loan is paid off. This is what makes title insurance unlike every other policy in the transaction. Hazard insurance covers future events, but title insurance covers past events that already occurred and simply haven't been discovered yet, which is exactly why the premium is paid once at closing instead of every year. Before any policy is issued, the title company searches the record and traces the chain of title, clearing problems it can find. The policy itself only covers what that search missed, or what the record could never reveal in the first place. Every policy also carries exceptions, like recorded easements or taxes not yet due, and endorsements exist to add narrow coverage back in, such as a survey endorsement for boundary problems or a mechanic's lien endorsement for unfiled liens. An endorsement always attaches to an existing policy. It never does the work of the underlying policy itself. Question 34. A deed is delivered and accepted but never taken to the county office, and the grantor later conveys the same property to a purchaser who knows nothing of the first transfer. Which of the following describes the risk the first grantee ran? Your options are: A. The unrecorded deed conveyed nothing at all. B. The grantor could not convey twice. C. The deed required witnesses to be valid. D. Recording would have given constructive notice. Take a second. Which answer would you pick? The correct answer is D. Recording would have given constructive notice. D is correct because recording imparts constructive notice to all subsequent purchasers of the contents of the instrument. An unrecorded deed remains good between the parties, but leaves the grantee exposed to a later purchaser without notice. A is wrong because delivery and acceptance transfer title between grantor and grantee. Recording protects that title against third parties rather than creating it in the first place. B is wrong because a grantor with no remaining interest can still physically sign a second deed. Whether that second deed prevails is exactly what the recording statutes resolve. C is wrong because witness requirements vary and are not what created this exposure. The problem is the absence of a public record that a later purchaser could have found. When two deeds exist for the same parcel, the law doesn't ask who signed first. It looks to the recording statutes because a buyer has no way to peek inside a stranger's desk drawer. A deed transfers title the moment it's delivered by the grantor and accepted by the grantee. Recording plays no part in that transfer. An unrecorded deed is completely valid between the two original parties, but what recording actually does is protect that ownership against everyone else. The mechanism is constructive notice. Recording an instrument in the county records imparts notice of its contents to every later purchaser, whether or not they actually looked. Because the record is available for anyone to read, actual notice is different and comes from genuine knowledge or from facts like someone else visibly occupying the property. A first grantee who takes delivery and never records leaves the record showing the grantor as owner. A second purchaser who searches, finds nothing, pays value, and knows nothing of the earlier transfer is a bona fide purchaser without notice. And under most recording systems, that second purchaser very often wins. The first grantee's deed was good the moment it was delivered, but her ownership stayed vulnerable every day it sat unrecorded. Recording doesn't create title, it shields the title you already have from anyone claiming ignorance of it. Question 35. A Missouri property manager and an owner sign an agreement covering an 8-unit building, and the manager asks what the document must specify about the tenant's security deposits and prepaid rents. Which of the following states a required item? Your options are: A. The bank branch where deposits are kept. B. Whether the broker or owner holds deposits. C. The interest rate the deposits will earn. D. A schedule of permitted deductions. Before I reveal it, which one do you think is right? The correct answer is B. Whether the broker or owner holds deposits. B is correct because 20 CSR 2250 8.090 requires a property management agreement to specify whether security deposits and prepaid rents are held by the broker or by the owner, among its other required contents. A is wrong because the rule addresses who holds the funds rather than naming a branch. The escrow rules separately require the account to sit at a bank, savings and loan or credit union. C is wrong because Missouri assigns interest on security deposits to the landlord by statute rather than requiring a rate in the management agreement. The rate itself is a banking matter. D is wrong because permissible withholdings come from the landlord-tenant statute rather than from the management contract. That statute allows only 3 specific categories of permissible deduction from a deposit. A property management agreement isn't a free-form contract. Missouri's commission rule dictates specific required contents because management puts a broker in continuous control of other people's money month after month, year after year. A listing lasts a few months and ends in one closing. A management agreement instead produces monthly rent collections, security deposits, prepaid rents, and owner distributions flowing continuously through accounts the owner cannot directly observe. Among the agreement's required contents is one specific answer. Does the broker or the owner hold security deposits and prepaid rents? That single allocation determines who is accountable, whose records must show the money, and which escrow obligations apply. If the broker holds the funds, that money is escrow money. It sits in a separate account, gets reconciled, and the broker answers for it under commission escrow rules. If the owner holds it, the broker's job is simply to deliver the funds and document that delivery. Escrow rules govern where and how funds sit. The landlord-tenant statute governs deposit interest and permissible deductions. The management agreement's job is narrower. State who holds the money before the first tenant's deposit ever arrives. Question 36. A property manager screening applicants for a large Missouri apartment complex applies the same income, credit, and rental history standards to every applicant who comes through the door without any exception. Which of the following describes that practice? Your options are A. Prohibited as disparate impact screening, B. Required to be filed with the Commission, C. Permitted only for market rate units, D. Consistent with fair housing obligations. What's your answer? Commit to one before I continue. The correct answer is D. Consistent with fair housing obligations. D is correct because applying uniform, job-related screening criteria to every applicant is the core of fair housing compliance and property management. Missouri also now preempts local ordinances restricting a landlord's use of screening methods. A is wrong because uniform application of legitimate criteria is the recommended practice rather than a violation. Disparate impact concerns arise from criteria that are themselves unjustified. B is wrong because no filing requirement of that kind exists. The Commission inspects broker records during ordinary business hours rather than collecting tenant screening policies from firms in advance. C is wrong because fair housing obligations attach regardless of whether units are market rate or subsidized. Consistent treatment of applicants is expected across a manager's whole portfolio of properties. Treating every applicant the same sounds risky, but that instinct has it backward. Uniform application of legitimate, business-related screening criteria isn't a fair housing violation. It's the strongest protection a manager has against a discrimination claim. Fair housing law bars discrimination in sale, rental, and financing based on race, color, religion, national origin, sex, familial status, and disability. And Missouri tracks these closely. The prohibition also covers different terms, different services, discriminatory statements, and steering applicants toward or away from certain buildings. Disparate treatment means applying rules differently based on a protected characteristic, like waiving an income requirement for one applicant but not another. Disparate impact means a neutral policy that falls harder on a protected group without a legitimate business justification. Uniform standards eliminate disparate treatment entirely since there's no differential treatment to point to. Written criteria applied in a fixed order turn the principle into practice. A manager who publishes income, credit, and rental history standards applies them in the order received and documents each decision has built a record that answers a complaint before it's ever filed. Screening one applicant more thoroughly than another is where liability actually starts. Missouri preempts local ordinances restricting screening methods, but federal fair housing duties still apply regardless, and that obligation covers a manager's entire portfolio, market rate or subsidized. because consistent treatment of every applicant is compliance, not a violation. Question 37. A Missouri commissioner spends a full day traveling to Jefferson City and attending commission business, and she asks what the statute allows her to be paid for that single long day. Which of the following states the limit? Your options are A. $75 per day, B. $100 per day, C. $50 per day, D. No compensation, expenses only. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. $75 per day. A is correct because Section 339 Etal 20 RSMO limits commissioner compensation to not more than $75 per day devoted to commission business, plus necessary expenses. The figure has stayed unchanged for many years. B is wrong because $100 exceeds the limit the statute names. That amount is the original issuance fee for licenses in the broker family instead. C is wrong because $50 understates the statutory ceiling. That figure does appear elsewhere in Missouri real estate law as the monthly charge for a delinquent license renewal. D is wrong because the statute provides both a daily allowance and reimbursement of necessary expenses. Service on the commission is therefore compensated, though the daily figure is a modest one. The Missouri Real Estate Commission is a real regulatory body, appointed by the governor and confirmed by the Senate, mostly experienced brokers plus one voting public member who holds no license at all. The statute caps a commissioner at $75 per day devoted to commission business, plus reimbursement for expenses actually incurred. That per diem structure, rather than a salary, fits a board that meets only periodically. And the expense reimbursement means serving never costs a commissioner money out of pocket. The $100 distractor is a real number, but it's the license issuance fee paid by licensees. The $50 distractor is also real, but it's a monthly penalty for a delinquent renewal. Both are genuine figures from the correct body of law, just attached to the wrong question. The habit worth building across this whole area of law is noticing which side of the relationship a figure sits on. Fees flow from licensees to the commission. Allowances flow from the state to commissioners. And penalties are paid by licensees who missed a deadline. The $75 figure has stayed unchanged for years because statutory dollar amounts never adjust automatically. Don't assume a compensation figure reflects current market rates, and always check which side of the transaction it belongs to. Question 38. A Missouri applicant has passed both portions of the examination and filed a complete application, and the commission has not yet finished its review or printed the license she awaits. Which of the following describes what she may receive? Your options are A conditional license valid for 1 year, B, a temporary work permit freely withdrawable, C, an inactive license pending final review, D, nothing until the license is issued. Which would you go with? Lock it in before the reveal. The correct answer is B, a temporary work permit freely withdrawable. B is correct because Section 339 Ozo 40 RSMO authorizes a temporary work permit pending final review and printing of the license. The Commission may withdraw the permit at any time at its own discretion. A is wrong because the permit is not a conditional license with a fixed term. It bridges the administrative gap and lasts only until the Commission acts. C is wrong because inactive status is a chosen status for a licensee who does not wish to practice. It authorizes no activity, which is the opposite of what a work permit provides. D is wrong because Missouri built this mechanism precisely, so a qualified applicant is not idle by processing time. The statute names this permit expressly and lets the Commission withdraw it whenever it chooses. An applicant can pass every exam, file a complete application, and satisfy every requirement the law demands. yet still have no license certificate simply because the commission hasn't finished printing it. That interval between full qualification and paperwork completion is a purely administrative gap. The statute authorizes a temporary work permit, issued while the application is still under review, that lets a qualified applicant start practicing under her broker right away. Its defining feature is that the Commission can withdraw it at any time, at its own discretion, which is exactly what makes issuing it safe before review is finished. A conditional license would run for a set period and give the holder a vested right, which is the opposite of this arrangement. Inactive status is something a licensee chooses when not practicing, authorizing no activity at all, while assuming nothing exists until the license issues ignores that the legislature expressly solved this problem. Picture the applicant's timeline: exam passed, application filed, then a gap before the license is printed. The temporary work permit sits in that gap, bridging it, always subject to the Commission pulling it back the moment something in the file raises a concern. When a STEM describes an applicant who has done everything required and is simply waiting on the agency, the temporary work permit fills that interval, and the phrase that gives it away is the Commission's freedom to withdraw it whenever it chooses. Question 39. A newly licensed Missouri salesperson expects her license certificate to arrive in her own mailbox at home, and she's surprised when several weeks pass and it never does. Which of the following describes where the Commission sends it? Your options are: A. To her associated broker, B. To the licensee's professional corporation, C. To the licensee's home address on file, D. To the school that certified her coursework. Don't overthink it. Which one feels right? The correct answer is A. To her associated broker. A is correct because 20 CSR 2250 to 4.050 provides that a broker salesperson or salesperson license issues only to a person associated with a licensed broker, and the license is mailed to that broker. B is wrong because a professional corporation is an optional entity a salesperson may form. It does not become the delivery point for the underlying individual license. C is wrong because the home address on file governs where commission correspondence and inquiries go. The license document itself follows the brokerage association rather than the licensee's residence. D is wrong because schools issue course completion certificates and play no part after the application. The license comes from the commission and goes to the supervising broker. A newly licensed Missouri salesperson never gets her certificate in the mail, and that's not a mistake. The commission mailed it to her broker exactly as the rule requires, because the routine reveals something structural about how salesperson licensure actually works. The association with a broker isn't an administrative detail attached to an otherwise independent credential. It's a condition of the license existing in active form at all. A salesperson without a broker has no one through whom she may lawfully practice. The broker is the person accountable for the licensee's conduct, the one who supervises her work and must account for who is affiliated with the firm. Placing the physical license in the broker's hands matches the document to the person responsible for the activity it authorizes. A professional corporation may exist for compensation purposes, but it never holds the individual license. Home address matters for correspondence, but the certificate follows the brokerage, not the residence. And a school issues only a course completion certificate with no role in delivering the license itself. A new licensee's ability to work depends on a relationship as much as an exam result. Career changers who plan the test carefully but leave affiliation to chance discover that the ordering matters. Question 40. A Missouri candidate finishes her 48-hour pre-examination course and schedules the licensing examination for the following week, before the school has issued her the course completion certificate she earned. Which of the following describes the requirement she overlooked? Your options are A. The certificate is required only at application. B. The certificate may follow within 30 days. C. The certificate must precede the examination. D. The school notifies the testing service directly. Got a guess? Lock it in. The correct answer is C. The certificate must precede the examination. C is correct because 20 CSR 2250 3.010 requires the pre-examination course to be completed and the completion certificate received before the candidate attempts the required examination. Scheduling ahead of the certificate puts the sitting at risk. Is wrong because the application stage is later still. The certificate accompanies the application as well, but the rule fixes an earlier deadline for attempting the examination. B is wrong because no grace period follows the examination date. The rule places the certificate before the test rather than allowing it to catch up afterward. D is wrong because the requirement runs to the candidate receiving her certificate. Any administrative arrangement between a school and a testing vendor does not replace that step. Missouri licensure isn't a list of boxes to check whenever. It's an ordered sequence, and one step must finish before the next begins. The rule requires the pre-examination course to be completed and the certificate received before the candidate attempts the exam. Finishing classroom hours isn't the same as holding the certificate. The certificate, not the last day of class, is the gate. The certificate is the school's formal attestation, a verifiable record that education was satisfied before sitting for the exam, rather than something reconstructed afterward from spotty school records. The application stage answer is half right, since the certificate does accompany the application. Deki equams, but the rule also fixes an earlier deadline. There's no grace period allowing documentation to catch up, and a school notifying a testing vendor doesn't replace the candidate's own obligation to have the certificate in hand. Missouri licensure is full of ordered steps: education before examination, examination and application before licensure, association with a broker before an active license, and continuing education before renewal. Reading for sequence, not just for a checklist, is what makes this material click. Question 41. A Missouri broker drafts a listing agreement that names the property, the price, and the commission, and states only that the listing runs until the property finally sells to someone. Which of the following describes what is missing? Your options are A statement of the buyer's financing terms. B. A definite beginning date and expiration date. C. The names of any cooperating brokers. D. A recital of the seller's motivation. Which one is it? Pause the video if you need more time. The correct answer is B. A definite beginning date and expiration date. B is correct because 20 CSR 2250 8.090 requires a seller's agency agreement to contain a definite beginning date and an expiration date among 14 enumerated items. An open-ended term fails that requirement. A is wrong because financing terms belong to the purchase contract negotiated later. A listing agreement governs the working relationship between the seller and her chosen broker instead. C is wrong because the agreement must state whether the broker is authorized to cooperate with and compensate other designated brokers, not name them individually. Cooperating firms are unknown at listing. D is wrong because a seller's reasons for selling are confidential information a licensee must protect. Recording them in the listing would be the opposite of what the rules contemplate. Open-ended listings once trapped sellers who couldn't hire another broker without a fight over whether the old agreement was still alive. Missouri's fix was simple. Require the agreement itself to contain the answer. Definite means an actual date on a calendar, not a condition like until the property sells. An agreement worded that way fails the requirement even if a broker also names the property, the price, and the commission. The expiration date works automatically. When it arrives, the agreement simply ends, with no notice, no termination, and no negotiation required, so an unhappy seller just waits out the term, while a broker who wants to continue must ask for an extension. One clause outlives the expiration date itself. A protection or carryover clause entitles the broker to a commission for a set period after expiration. If the sale goes to a buyer the broker introduced, and it stops applying once the seller lists elsewhere. The definite expiration date isn't a technicality, it's the seller's guaranteed exit, no accusations required. Question 42. A Missouri licensee prepares a written offer identifying the property only as the White House on Oak Street with the large maple tree standing in front of it. Which of the following describes the requirement she has missed? Your options are A. A recorded plat must accompany every offer. B. The offer must state the assessed valuation. C. The offer must attach a current survey. D. The offer must identify the property unmistakably. Take a second. Which answer would you pick? The correct answer is D. The offer must identify the property unmistakably. D is correct because 20 CSR 22-8-100 requires every written offer to include the legal description, the complete street address with city, or a description that unmistakably identifies the property. A landmark reference falls short. A is wrong because the rule offers 3 acceptable ways to identify a property and does not demand a plat. A complete street address with the city satisfies it directly. B is wrong because assessed valuation is a tax figure with no bearing on identification. It appears in the assessor's records rather than in the terms of an offer. C is wrong because a survey addresses boundaries and encroachments rather than identifying which property is being sold. Nothing in the Missouri offers rule requires a survey to accompany a written offer. Everyone might recognize the White House with the maple tree on Oak Street, but that description is still legally inadequate. The reason has nothing to do with confusion between the parties, and everything to do with what a written offer must accomplish. The Commission's rule requires every written offer to identify the property in one of 3 ways: a legal description, a complete street address including the city, or a description that unmistakably identifies the property. Unmistakably is demanding because it asks whether a stranger to the deal could pinpoint the parcel. Landmarks fail that test since trees get cut down and houses get repainted. This traces back to the statute of frauds, which requires a land sale contract to describe the property well enough that a court could enforce it. If the description fails that test, a buyer who did everything right may find she cannot compel the sale through specific performance. 3 systems handle nearly all Missouri property. Meets and bounds measures boundaries by direction and distance from a starting point. Lot and block identifies property by lot number within a recorded plat. And rectangular survey locates rural land using townships, ranges, and sections. No plat, no survey, and no legal description is required for a written offer. A complete street address with the city satisfies the rule directly, while assessed valuation and surveys answer entirely different questions and identify nothing on their own. Question 43. A Missouri seller accepts one offer and a second buyer then submits a properly identified backup offer that the listing agent decides not to bother presenting to her own seller client. Which of the following describes that decision? Your options are incorrect since backup offers must be presented. B. Correct since the property is under contract. C. Correct if the seller instructed her orally. D. Correct if the backup is lower. Before I reveal it, which one do you think is right? The correct answer is A. Incorrect since backup offers must be presented. A is correct because 20 CSR 2250-8.100 requires prompt tender of every written offer and expressly includes properly identified backup contracts. Section 339-100 RSO makes failure to inform sellers of all written offers a disciplinary ground. B is wrong because an existing contract does not relieve the licensee of presenting later offers. A seller may well want a backup in place if the first transaction collapses. C is wrong because only a written instruction from the seller changes the obligation. An oral remark at a kitchen table does not satisfy the narrow exception the statute allows. D is wrong because the price offered is the seller's own judgment to make. Screening offers by amount substitutes the licensee's assessment for a decision belonging to the client. Deciding which offers a seller gets to see is not the licensee's call. That single principle explains why Missouri regulates offer presentation directly, rather than trusting it to professional judgment. The Commission's rule requires prompt tender of every written offer, including properly identified backup contracts. The statute reinforces it from the other side, making it a disciplinary violation to fail to inform a seller of all written offers. A backup offer matters because a signed contract can still collapse. Financing falls through. Inspections produce impasses. Appraisals come in low and buyers change their minds. A seller with a backup buyer already in position avoids returning to the market carrying that stigma. Only a written instruction from the seller changes this obligation. An oral remark at the kitchen table is unprovable and doesn't count. And screening a backup offer because the price seems too low is the clearest violation, since sellers accept lower offers for reasons agents can't always see. Presenting an offer is not endorsing it. Any filtering of offers for a reason short of a written client instruction is a violation. The licensee's job is to deliver the information and let the seller decide. Question 44. A Missouri broker delivers closing statements to both parties, and the buyer asks what the document must show about the money the broker actually handled during the transaction itself at closing. Which of the following is a required item? Your options are A. The lender's underwriting file number, B. The broker's annual commission volume, C. The payees of all broker disbursements, D. The listing agent split with her broker. What's your answer? Commit to one before I continue. The correct answer is C. The payees of all broker disbursements. C is correct because 20 CSR 2258-150 requires the closing statement to show all material financial aspects: the true sale price, earnest money received, mortgages of record, all money the broker received, and the amounts and payees of all disbursements. A is wrong because internal lender file references serve the lender's processing. The statement records the financial terms of the transfer itself rather than any administrative identifiers used by others. B is wrong because a brokerage's overall production is business information unrelated to the transaction. The statement accounts for money in this file rather than describing the firm. D is wrong because how a firm divides its commission internally is between the broker and her licensee. The statement discloses what the parties paid and who received it. A duty to account for other people's money is easy to claim and hard to prove later. That's why Missouri requires it in writing, at closing, in a document showing exactly where every dollar went. The rule specifies exactly what must appear: the true sale price, the earnest money received, mortgages of record, and all money the broker handled. The most tested item names both halves of disbursements, how much went out and to whom. Naming payees turns a summary into an accounting. A total tells you money left the account, but a list of payees, the title company, the lender, the county, the surveyor, lets a party verify each payment against an invoice. The word true is doing real work here. A statement that misstates the actual price to mislead a lender or tax authority creates a document with consequences far beyond a license violation. Common distractors test whether you know who's accounting this as: lender file numbers, the firm's annual commission volume, and the commission split are internal matters, not part of what buyers and sellers are entitled to see about their own transaction. Question 45. A Missouri broker holds an interest-bearing escrow account and receives the monthly bank statement showing interest credited to a client whose earnest money deposit she is holding. Which of the following states when that interest must be disbursed? Your options are: A. At the closing of the related transaction, B. Within 30 days of the calendar quarter, C. Annually when the account is reconciled, D. 10 banking days after the next statement. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is D. 10 banking days after the next statement. D is correct because 20 CSR 22 A2120 requires interest payable to be disbursed to the appropriate parties no later than 10 banking days following receipt of the next statement, and interest payable to a licensee removed on the same schedule. A is wrong because the interest obligation runs on its own schedule. Closing governs when commissions come out of escrow, which is a separate requirement in the same rule. B is wrong because the rule counts from the arrival of the next bank statement rather than from a quarter end. A quarterly cycle would leave client money sitting far longer. C is wrong because an annual sweep would leave interest accumulating in the account for many months. Missouri chose a short cycle tied to the statement the broker actually receives. Interest on escrow money belongs to the client, not the broker, and Missouri does not let a broker decide when to release it. The Commission's escrow rule ties the deadline to an event no broker controls. The rule requires interest to be disbursed no later than 10 banking days after the next statement arrives. That statement tells the broker exactly how much accrued, so the obligation is self-executing, and banking days remove any need to interpret weekends or holidays. The rule pushes money in both directions at once. Client interest goes out to the client, and any interest payable to the licensee must also leave the trust account on that same schedule, because broker funds sitting in escrow is commingling, a separate violation. Closing is a real deadline for commissions, but interest accrues continuously and isn't tied to a transaction event. A quarterly cycle could leave funds sitting 3 months past the statement, and an annual sweep is worse, letting interest pile up for a year. Watch for the phrase interest-bearing escrow account paired with a disbursement question. The bank statement starts the clock and the count runs in banking days, not calendar days. Question 46. A Missouri owner gives a broker written permission to enter and show a house while they continue negotiating a full listing, and the broker asks what that short written document must contain. Which of the following is required? Your options are: A. A statement of the owner's asking price, B. A recital of the property's tax assessment, C. Permission to enter and show the property, D. An estimate of the marketing budget. Which would you go with? Lock it in before the reveal. The correct answer is C. Permission to enter and show the property. C is correct because 20 CSR 2250 8.090 lists the contents of an other written authorization to show, including beginning and expiration dates, signatures of all owners, an identifying property description, permission to enter and show, and the commission or fee. A is wrong because price appears among the required contents of a full seller's agency agreement rather than the shorter instrument. The authorization exists to permit showings, not to set terms of sale. B is wrong because assessed value plays no part in any of the required contents. The identifying description may be a legal description or a complete street address with city. D is wrong because marketing plans are business decisions rather than regulatory requirements. The rule sets out what the document must say to authorize entry and showing lawfully. There is a gap between a handshake and a signed listing. An owner wants a broker to show the house this weekend while commission and price are still being negotiated, and Missouri fills that gap with a short instrument. The rule spells out compact requirements, beginning and expiration dates, signatures of all owners, a description identifying the property, permission to enter and show, and the commission or fee. Permission to enter and show is the operative term, distinguishing this document from every other agreement in the file. A legal description or a complete street address with city satisfies the identifying requirement, the same standard used elsewhere in Missouri's rules. The dates matter because an authorization that never expires would be an open-ended grant of access to someone's home, so the instrument is built to end on its own. Price belongs in the full seller's agency agreement, which governs marketing and negotiation, not in an instrument meant only to permit entry while terms are still under discussion. Tax assessment appears in none of the required contents, and a marketing budget is simply a business decision no Missouri rule requires. This short form exists precisely so a broker can open a door for a Saturday showing without a survey, a price, or a signed listing standing in the way. Question 47. A Missouri salesperson receives cash from a buyer for an inspection fee, spends it on other expenses, and does not remit or account for it when the transaction finally closes. Which of the following identifies the disciplinary ground? Your options are A. Assisting an unlicensed person to practice. B. Failing to account for client money. C. Accepting compensation from other than her broker. D. Making substantial misrepresentations to a party. Don't overthink it. Which one feels right? The correct answer is B. Failing to account for client money. B is correct because Section 300 and 39100 RSMO makes failing to timely account for or remit money or property belonging to others a ground for discipline. The escrow rules separately require immediate delivery of funds to the broker. A is wrong because no unlicensed person appears in this scenario. That separate ground reaches a licensee who helps another person practice without the credential the law requires. C is wrong because that ground addresses a licensee taking a commission from someone other than her own broker. The buyer's inspection fee is not compensation for licensed services. D is wrong because nothing in these facts involves a false statement about the property or the transaction. The wrong here is the handling of money rather than a misstatement. When a licensee holds someone else's money, that money is the most dangerous thing she handles. Not because the amount is large, but because failing to remit or account for it is a clear, permanent, and severe violation. The statute names two separate verbs, remit and account. Failing to remit means the money was never delivered. Failing to account means there's no record of where it went. A licensee who eventually hands back the funds but can't explain the gap has still violated half the duty. Escrow rules reinforce this by starting the duty even earlier. A salesperson who receives funds must deliver them straight to her broker, since she has no authority to hold client money herself. The broker is the one who maintains the escrow account and answers for the funds. Prevention here is procedural, not moral. Funds go to the broker right away. Receipts get issued. Cash is discouraged and documented when it happens, and records track what came in, from whom, for what, and where it ended up. A licensee who follows those steps never has to reconstruct anything later. The size of the fee never softens the analysis. Whether it's a small inspection fee or a large deposit, the breach of trust is what licensing exists to catch. Question 48. The Missouri Real Estate Commission subpoenas a witness to testify at an investigatory hearing, and the witness asks what she will be paid for taking a full day off to appear. Which of the following describes the statute? Your options are: A. No fees are paid to commission witnesses. B. Fees are set annually by the commission. C. Fees match civil circuit court cases. D. Fees are paid only to expert witnesses. Got a guess? Lock it in. The correct answer is C. Fees match civil circuit court cases. C is correct because Section 339(100) RSMO provides that witness fees in commission proceedings match those allowed in civil cases in circuit court. The commission may issue subpoenas and compel witnesses to appear. A is wrong because compelling attendance without any allowance would place the burden entirely on private citizens. The statute instead ties the amount payable to a fee schedule that already exists for civil cases. B is wrong because the Commission sets license fees by rule rather than setting witness fees. Borrowing the civil court schedule keeps this consistent across state proceedings. D is wrong because the statute draws no distinction between expert and lay witnesses. The fee provision applies to every witness compelled to appear before the Commission, whatever her role. An investigation is only as strong as the testimony it can compel. Missouri gives its real estate regulator the power to subpoena witnesses, and any witness compelled to appear is entitled to a fee for the day she gives up. The statute fixes the fee by borrowing an existing schedule rather than legislating a new figure. Witness fees in commission proceedings match those in civil circuit court cases. That means the amount updates automatically whenever the civil schedule changes, and it keeps compensation consistent instead of producing a patchwork of different rates. The subpoena power itself is the more consequential grant. The Commission can compel attendance and require production of documents from a licensee under investigation, a former client, a competing broker, or a bank employee holding escrow records. Missouri also splits the adjudication process. The Commission investigates and files a complaint. A separate administrative hearing commission decides whether a cause for discipline exists, and only then does the Real Estate Commission hold a hearing on what discipline to impose. Separating who decides the facts from who imposes the sanction protects the licensee, and it's why the compelled witness fee simply borrows the civil schedule rather than inventing a new one. Question 49. A Missouri licensee represents a client as a seller's limited agent on one property in the spring, then serves the same person as a transaction broker on a different purchase that autumn. Which of the following describes that arrangement? Your options are: A. Permitted since the transactions are separate. B. Prohibited once a limited agency exists. C. Permitted only with commission approval. D. Prohibited within the same calendar year. Which one is it? Pause the video if you need more time. The correct answer is A. Permitted since the transactions are separate. A is correct because Section 339(720) RSMO allows a licensee to work with the same party in separate transactions under different relationship types. Each transaction carries its own agreement, disclosures, and written confirmation. B is wrong because a relationship ends with the agreement that created it. Locking a client into one relationship type permanently would ignore that she plays different roles over time. C is wrong because the Commission approves no individual relationships. Its rules prescribe what agreements must contain, and when disclosures are due rather than clearing arrangements case by case. D is wrong because no waiting period appears in the statute. The provision permits this arrangement outright, provided each separate transaction is documented on its own terms. In Missouri, a brokerage relationship isn't a permanent bond with a person. It's tied to a single transaction. It's created by a written agreement, it governs one deal, and it ends when that deal ends. Because relationships reset with each transaction, A licensee can serve the same client differently over time as a limited agent representing one side with loyalty and confidentiality, as a transaction broker assisting both sides honestly without advocacy, or as a designated agent appointed within a firm handling both sides. This flexibility only works because each transaction carries its own paperwork, a written agreement establishing the relationship, required disclosures explaining what the licensee is and isn't doing, and written confirmation memorializing it all. Skipping that documentation is what actually creates confusion, not the change in relationship type itself. Picture the same client selling a house in spring as a limited agent's client, then buying an investment property that autumn as a transaction broker's client. 2 transactions, 2 agreements, 2 sets of disclosures, and 2 distinct, properly documented relationships. An agency ends when its agreement ends. Only confidentiality and accounting survive termination, and neither blocks a new relationship. There's no commission pre-approval and no cooling off period. Each transaction simply needs its own proper documentation. Question 50. A Missouri property owner who will be out of the country during closing signs a written instrument authorizing her sister to execute the deed and the closing documents on her behalf. Which of the following identifies that instrument? Your options are A. An assignment of contract, B. A power of attorney, C. A letter of intent, D. An estoppel certificate. Take a second. Which answer would you pick? The correct answer is B. A power of attorney. B is correct because a power of attorney is a written instrument creating an agency relationship and authorizing the named person, called the attorney in fact, to act for the principal. It must ordinarily be recorded to convey real property. A is wrong because an assignment transfers a party's rights under an existing contract to someone else. The owner here keeps her own contract rights and simply authorizes someone to sign for her. C is wrong because a letter of intent expresses a willingness to negotiate toward an agreement. It grants no authority to act on another person's behalf at a closing table. D is wrong because an estoppel certificate confirms the current status of an obligation, such as a lease or a loan balance. It verifies facts rather than conferring signing authority. When a Missouri owner can't be at her own closing, she can't just ask her sister to sign for her. A deed signed by the wrong person conveys nothing, so the law requires a written instrument authorizing someone else to act. That instrument is a power of attorney. The person granting authority is the principal, and the person receiving it is the attorney in fact, an agent appointed by writing rather than by profession. The document sets the scope of what the agent may do, and anything done within that scope binds the principal exactly as if she acted herself. A general power of attorney grants broad authority over the principal's affairs, while a limited or special power grants authority for one specific transaction. Like signing at a single closing, anyone reviewing the document reads the scope first, because authority over bank accounts is not authority to convey real estate. A power of attorney used to convey real property must ordinarily be recorded in the county where the land lies. This protects the chain of title, so a future title examiner reading a deed signed by someone other than the owner can find the document proving that signer's authority. A power of attorney always terminates on the principal's death, which is why closings confirm she's still living. An ordinary power also ends if she becomes incapacitated, but a durable power expressly survives incapacity, which is why estate planning relies on it. And the attorney in fact must sign in the principal's name while indicating that capacity, so the signature shows the owner acting through her agent. And with that, we've finished today's full practice review. If you'd like more practice with everything we covered, check out the website linked in the description below. You'll find hundreds of free practice questions plus detailed study guides to help you truly master this material, a great way to reinforce today's lesson and keep building your skills and confidence. Subscribe to stay with us for the next round of questions, and good luck on your Missouri Real Estate Salesperson exam.